All right. Greetings, everyone, and welcome. I am Dr. Laura Chavez, the Director of Research and Data at the Clean Slate Initiative. Um, I am very excited to be hosting this webinar today on advancing clean slate research. We have an all-star panel of researchers doing work in this space. Colleen Chen, Professor of Law at UC Berkeley, Dr. Nairon Crawford, Associate Professor of Political Science at Temple University, and Dr. J.J. Prescott, the Henry King Ransom Professor of Law at the University of Michigan. Each of these scholars has done and continues to do work that has helped shape the field of research on clean slate policies. So I am really looking forward to our panel. We will be discussing impacts of Clean Slate, implementation fidelity, notification and awareness, and the role of automation technology in delivering relief at scale, as well as where critical gaps remain for future research. We will have some time at the end for questions, so please submit those through the chat. I will monitor and we will get to them in the last 5 or 10 minutes of the webinar. So with that, I'd love to jump right in and first give each of our panelists a moment to briefly introduce themselves and say a little about the clean slate research that you've each been involved in and that's in the works. So let's start with Colleen.
Hi, it's a pleasure to be here. Thanks so much for having me. Hi, I'm Colleen Chen from Berkeley Law School, and for the past several years, I've been involved in research on measuring the gap, the second chance gap between uh, expungement remedies that are available on paper and those that are actually delivered, and sort of measuring the low uptake of petition-based expungement. As Clean Slate has been very successful, I've done more recent research at looking at, even once the laws are passed, what is the difference between what the states are delivering in terms of expungement and what is actually promised on paper. So what's something we can call the second chance gap. And later, I think we'll be able to discuss a little more some new research now on notification and how people are notified about their automated expungements.
All right, Dr. Prescott.
Hi, thank you very much for inviting me, Laura. Really happy to be here. I am an economist as well as a lawyer, and my work in this area really started with a paper in 2020 that looked at the experience of petition-based expungement in Michigan. My collaborator Sonia Starr and I established a few, I think, now conventional wisdom or pieces of conventional wisdom about at least petition-based expungement. One is that eligible individuals are oftentimes not pursuing expungement even when they're eligible. Colleen has done great work trying to measure that. We identify a very low rate eligibility uptake as well. We also spend time trying to identify the effects, the employment effects of record relief, show quite strong changes in people's experiences even 1 year out. And finally, we try to document what the possible impact of expungement is on criminal recidivism. And we find that there's no evidence that it affects recidivism in a bad way and may actually improve recidivism rates. And in particular, we find that people who received expungements are really low risk to begin with. More recently, I've published some work that has looked at petition-based expungement in the city of Detroit, working with Project Clean Slate in the city. We wound up surveying almost 1,500 applicants, and we've asked them a bunch of questions that really, at least I hadn't been able to get to or get at with the more administrative data-driven approaches I've used in the past. Motivations for seeking expungement, barriers, experience, and then a range of kind of unusual outcomes as well. We find a bunch of different and interesting things, but I'll just say a couple of them. One is that we find that, again, many individuals who are eligible never file, but there are also a bunch of people who start the process, but then wind up abandoning that process. And so trying to figure out why that happens is pretty important. Also found in terms of outcomes, pretty huge outcomes in terms of psychological and reputational relief. Those are really hard to measure generally. And also something that I think is important is changing views about procedural justice or the legitimacy of the system. So people who have received expungements tend to view the system as more fair relative to before, and also importantly, when the system doesn't work as it should, for example, if you're eligible for automatic expungement and you wind up not receiving it for some reason, even though you're supposed to, that can be a real problem in terms of what people think about the system. So we kind of want these systems to work well. I have ongoing work also looking at automated expungement in Michigan, but I think that's plenty for now. Thanks. Sorry for taking so much time.
Nope, that's great. Thank you. Take all the time you need. Dr. Crawford.
Good afternoon, everyone. I'm always delighted to be in this space, so I want to thank Dr. Chavez for continuing to invite me to be a part of these sessions. My name is Nyron Crawford. I'm an associate professor of political science and public policy at Temple University. And it's fitting that I go last because a lot of my work has been inspired by reading Dr. Prescott and Dr. Chen's work. Most of my work focuses on administrative burden as it relates to take up of petition-based expungement. And focusing on learning costs, psychological costs, as well as compliance costs, all of the things that potentially facilitate the second chance gap that Dr. Chen talked about. I also supported Dr. Chavez last year with the impact and awareness survey that was conducted by Clean Slate Initiative. And I'll be talking about some of those results today, and I'm excited about that.
Fantastic. Thank you all so much for joining us today. So I want to hop into the next question, which is for each of you. What do you think the research community understands really well at this point when it comes to record sealing policies? And where do you think we still have more to learn? Let's start with Colleen.
Sure. So I think one theme that came across, hopefully in all the responses already, is that we know that petition-based expungement has a lot of problems with it, and that despite how transformative expungement can be, there is very low uptake, and that there are a lot of barriers to people actually exercising their ability to get the expungement that they are eligible to receive under the law. And I think that a lot of what sort of Dr. Crawford referred to, and Dr. Prescott as well, in terms of what is the expectation, how do people understand what their opportunity is, the gap between that and actually being able to go through a process is pretty significant. And that, I think, helps us understand also the response potentially to automated expungement. Because I think what we're starting to see here, and I'm not sure if we know this, sort of a document as much as yet as well, that there are a host of implementation challenges also related to automated expungement that make it difficult for the state to deliver on its promised relief, whether it be things like, as some of my research has suggested, and there's also some great research coming out of the Harvard Access to Justice Lab, where there may be a difference between what is sort of in the policy with respect to where there should be automated expungement and the records themselves, that the fidelity may not fully be there. That can pose a barrier. Also, the issue that in many of the cases where laws are passed, we don't have broad notification campaigns. And so we don't really know yet, can these policies actually make a difference if people don't fully know that they could benefit from them? Is there going to be some sort of mechanical effect that we can observe, or is notification need to be part of the answer? So I think we know that that is an area that needs a lot more research.
Thank you, JJ.
Yeah, great. Yeah, so a lot of these are just spins on what Colleen just suggested. I mean, I think we definitely know that criminal records cause a lot of harm, and that record relief can cause substantial improvement in people's lives, and also potentially improvement in how people view the system and interact with it. I do think that the big questions, of course, relate to automatic expungement and how that is going to change what we know about this. I mean, obviously, automatic expungement in some important way solves the uptake problem, but as a result, when it does that, it changes the entire treatment. And so we don't know exactly yet how that's going to matter for how people respond to the record relief, whether or not the set of people who, the set of people are going to be different, and they're going to either need or not need that kind of relief in different ways. And I just want to emphasize that it seems like a big part of what we still need to learn a lot about is implementation. I don't think I think we all anticipated it would be difficult to implement this, but I think it is certainly in Michigan, it is a non-trivial constraint. And to the extent we think that uptake is the problem or the chief problem with petition-based expungement, it is implementation and relying on government communications and people following up on their responsibilities. That's an entirely different set of important questions. And I think some of those develop. They actually are going to lead to kind of third generation problems, like how people view those different kinds of failures. I guess one thing to think the petition based system is really difficult to use, it's really challenging, and maybe sometimes even the outcome is unfair. It's a different thing when the government kind of promises you something and then doesn't deliver on that, and some of those consequences may be a lot worse. So I think we need to learn about that. Thanks.
If I can, I'll add just a few thoughts to kind of echo what Colleen and JJ said. And we understand that I think these processes can facilitate economic stability and mobility for people who have criminal records. But I want to take a different approach than JJ and offer that I think that the challenges that we have related to implementations are actually good problems, insofar as criminal record clearance, automated clearance is actually proof of concept as it relates to policy reform. So we have an available solution that can be worked through, and I think we have proof of concept, and I think that's important as we think about trying to expand Clean Slate to other states.
Great, thank you. And that moves us into the next question, also for all panelists. As we shift from petition-based systems to larger scale clean slate policies, what are we starting to learn about the impacts of automation? So let's start with Myron and with records.
I think in general, people are reporting positive benefits to automation. We know that there have been improvements in financial situations, in family arrangements. We know that people prior to having their record cleared were experiencing significant burdens as it relates to finding employment, finding housing, and pursuing education. And so the benefits have been profound, at least at how people have perceived their ability to move through the world economically and establish workforce opportunities. And so I think across a variety of different domains, we're seeing people express benefits from these automated processes.
JJ.
Yeah, I mean, I think I pitched a lot of the things I think we're starting to learn already. I'll say that one of the things I think we're learning, again, we expected implementation to be difficult. I think we are learning about the nature of those problems. So in Michigan, for example, we have some documented situations where certain things just aren't happening that are supposed to happen, and other with respect to one agency, and then other kinds of problems that are happening in the courts. I think that is the kind of learning that we have in order to kind of improve on both the design of the system and how we reinforce it and make sure it operates well. I also think that we're already learning that both notification matters. Like it really does matter to people. People certainly don't know that they've received an expungement automatically in many instances. And sometimes even when they've received one, they're not really sure how they've received it, according to some of our survey based research. And I want to just reemphasize the potential role of both of these kinds of systems in legitimacy and how people view the system. I think we're starting to learn that how people react to these policies matters a lot for the kinds of responses that the government is going to get to other kinds of policies. So the kind of the knock-on effects or the spillovers, I think, are going to prove to be important, and I think that should increase the care with which government does this sort of thing. It's important to do it, and then it's important to do it right, and to not stint on how you do it.
And I'll just add to those two excellent answers that there is a lot of variation in how states are actually implementing, a lot of differences in how the state infrastructure are set up. So I think what we're learning also is that there's going to be lessons that we can learn that we can generalize, perhaps with respect to thinking about the impact, but each state has its own set of challenges. So for example, in California, we have both our state level repository of data, and that was cleared in 2024. A lot of the records under the Clean Slate Acts that we had there, but now getting the counties to get engaged is important because we have county level records, which a lot of background check companies are going to be involved in. So some of the research is actually quite important because we need to convince potentially the counties to carry out their stage of implementation. And so engaging them and doing early research, I think, can show why this is beneficial, why this is important. I would also say that there's a lot of heterogeneity we're seeing across states with respect to how they're setting up information portals and notification campaigns for letting people know what's out there. And so I think a lot can be learned there as well in terms of what's the effectiveness of different outreach strategies, what works and what doesn't, which populations in particular want to be reached in what way. There's still a big agenda there, I think, to learn how to actually notify people effectively.
Laura, can I add one additional point to JJ's point about spillover effects? So one of the things we know from the extant research is that people who've had contact with law enforcement or the criminal legal system tend to withdraw from public systems. And it's part of the reason that petition-based expungement is problematic, is part because folks don't want to engage with systems that they don't think serve them well. And I think that Clean Slate is an example of government working for a group of people who are typically policy losers in this context, right? And so the fact that we have Clean Slate is one example of where they are actually being policy beneficiaries. And so when JJ talks about the spillover effect, I actually think there's a lot there that we don't know. Whether or not having a record cleared actually increases participation across political behavior, not just voting, but across different things, whether they're engaging in programs that are unrelated to the criminal legal system, are things that we don't yet know, that I think there is ripe for research later. Thinking about the psychological impact of being a policy beneficiary, I think is something that we don't know and ought to start thinking about moving forward.
Yeah, just to jump in there, that's exactly right. I think in some of the survey work I've done in Detroit, we find that people view the criminal justice system and the legal system more positively after they receive this kind of relief. And one would expect that that would manifest in a bunch of different ways, not just in terms of their subjective views of the system, but also in their behaviors. And in fact, can't remember exactly what we find, but I'm pretty sure in our survey based work we document that not only are there sort of just general psychological benefits, but that people report being able to do more things, for example, with their family, to participate in activities at school. That's, I think, where the rubber hits the road. When you talk about avoidance behavior, people who are scared of interacting with the system, they don't go to school, they don't vote. Sorry, they don't go to school with their children. They don't participate in that, and I think it would be great to more fully document some of those effects. I think it would show just how powerful these kinds of policies can be.
Yeah, absolutely. Thank you so much. Thank all of you. JJ, I have a question for you. Your work on petition-based expungement in Michigan showed substantial gains for people who successfully applied. How should we think about that evidence when we're evaluating automated systems that intentionally remove self-selection from that process?
Yeah, great. Thank you very much. I think in some important ways that work shows us what's possible and also gives us even just the problem of the selection issue when it comes to thinking about employment, for example. I think it gives us some insight into where we think that issue will be most important. So I think we know that expungement can matter, and it can matter causally for an important subset of the population. We do know that that being willing to petition makes you somehow like a little bit different from other people. um, that suggests that we, instead of thinking of what we found in that 2020 paper as sort of the expected improvements, we might think about it as an upper bound in terms of the effects it's going to have on some people. And now we're more interested in something like the population average, if we're going to expand this out to a lot more people. What's important to realize is, because the uptake gap, even if the effects are smaller individually, the overall aggregate effect on welfare may be much larger. And so that's really really important to realize. One of the areas where we would think that this issue about motivation and selection would matter a lot would be with respect to employment. Wage gains and employment require job search, applications, interviews. They are, motivation matters there. And if somebody's not actively seeking work or is out of the labor force, removing the record may not have much of an impact. And we don't really know what's going to matter there. But there are a lot of other important outcomes that may be less motivation dependent. I mean, for example, housing. Housing depends a lot on records and how people are viewed during the application period. And even if you have somebody who's not highly motivated or upwardly mobile in terms of trying to seek jobs or trying to improve on that dimension, they still need housing. And so it's possible they may not move as much, but it seems that housing is likely to be less of an issue there. So if we can document petition-based expungement benefits in terms of housing, I think those are likely to be really useful in how we anticipate the likely automatic expungement effects, at least if we think the people have been notified and are aware of it. There are a bunch of other types of outcomes that I think are also potentially less motivation sensitive, like licensing, like occupational licensing, for example. Like it may be that that some of these things are sort of automatic triggers that remove you from certain areas, and then they just flip off, and you're back to where you were. The psychological and reputational effects are likely to depend less on motivation and labor market effort generally. And I think one of the things we've been talking about is just procedural justice, how people view the system. Again, I think that seems to be less likely to be sensitive to these kinds of selection concerns. So I think all of this is to say, even in the context of employment, where we might think that issue is the most significant, there are good reasons, even in that literature, to think that that motivation isn't explaining it all, or even the most important part of it. And with automatic expungement, the effects are likely to be much more widespread. And so, if instead of having a 25% increase in expected wages, maybe it's much smaller than that. But much smaller than that would still be huge. And taking that and making it 15 to 20 times as large in terms of the number of people affected would be incredible. But on top of that, there are all these other really important outcomes. They get less attention maybe because they're harder to measure. We don't have the same reason to think that motivation or selection would be an issue in thinking about how those benefits move over from petition to automatic expungement.
Yeah, that's great. Thank you. And that leads right into the next question that I have, which is for Colleen. Colleen, you're working right now on a pre-pilot. You've called it the Digital Juneteenth Project. It highlights outcomes like engagement, human capital investment, trust in legal institutions, things that typically don't show up in short-term wage or employment data. You also emphasize the importance of mixed methods where qualitative responses reveal forms of agency and momentum that purely quantitative evaluations could miss if they're just using administrative data. So from your perspective, how should the Clean Slate research agenda evolve to capture more intermediate or pathway outcomes better, particularly as your notification project moves into a rigorous randomized control trial?
Thanks so much for the question. And I do want to sort of echo some of the themes of the earlier panelists around the kind of variety of different ways in which this can change somebody's outlook, their perspective, and what they're actually going to do on a longer term. In particular, with respect to this question of systems trust. Again, I'll explain what we've done so far in a very small pre-pilot as we get ready to scale. But we are seeing, I think, I'll kind of go into that one particular finding. We did see that we asked them, well, what's your impression of the notifying agency, which we are working with the public defender of Santa Clara County. And they said, well, this, it's really changed my opinion of the system. We previously think the phrase was used, we thought of the public defender as a public pretender, but now things change because of this. And this is obviously just a very small data point, but I think the value of actually asking people, whether through survey or through surveys, what they're how they're feeling about various on various topics, as well as looking at other types of administrative data. That is what we're seeking to do. So just to kind of give a little bit of context, I, together with people at the Paper Prisons Initiative, which is out of Berkeley Law, we are now, several of us are embedded in the Public Defender's Office of Santa Clara County. That county has over 100,000 people who have benefited from local clearance as well as state level clearance. And so we are now in the process of figuring out how to notify a subset of them and to test a number of different strategies to figure out what's the best way of notifying people, how can we engage them, get them to even open the message, understand what's there, and then potentially also help them in other ways. That's organically because the public defender wanted to, not just have a one-off contact where it was going to be, here is the information we want to provide to you, but also wanted to say, would you like a letter for your employer? Would you like to find out more information about what's on your record or get other questions answered? And so we've only started the process. It took us a long time to kind of create the infrastructure. But out of the 50 people we were able to send emails to that were not bouncing, we had a much higher engagement rate than we expected. We had about 42% of people responding and saying, yes, we got the message. And of those, 57% actually asked for an additional service. So I think this kind of goes back to thinking about petition-based expungement as not being sort of a one-off process, but being one where you prepare for the expungement, you file it, and then you potentially take further action. Here, there's also the kind of way that we're putting out notification would be about telling people that they're notified, but also giving them a chance then to engage further and to understand fully what this means for their record, what other records might still be present that they could clear. Could there be something they could use to help them with their employer? Now, JG's comments, I think, maybe really think about how do you get unblocked? Like, where are your records actively blocking you? So I think that, again, doing survey research and trying to really talk to folks who are getting these notifications to understand where they're at, and there's sort of other survey projects I think going on, is really important to say, how can this notification, how can this newly cleared record actually start to deliver value immediately, right? Not only in terms of your own impressions of the system or your own sense of confidence, which are extremely important, but also more generally, are there specific areas where this new expungement could actually be used to help you get a better opportunity, start to volunteer, be civically engaged, or think about an education opportunity or something along those lines, which then can lead to a labor outcome. So I think from our perspective, trying to be able to look at different ways of measuring outcomes, whether it be through surveys or through partnerships with other county entities, which also observe engagement with their services, will give us a way to try to figure out if there's other outcomes in addition to, of course, the classic or very important looking at the criminal justice involvement, recidivism, as well as the labor market. We're trying to take a look at broadly which different systems we can look at to gauge the impact.
Can I jump in on and add something, Laura? Like, I mean, what Colleen's talking about, I think it's so important, and what it makes me realize is that really, even with automatic expungement, we still have to think about uptake, because conditional on actually having, an expungement, you then have to actually use it in lots of ways. And there are good reasons to think that that we can do a lot more on that. So in addition to providing somebody with an expungement automatically or supporting them in the petition-based expungement, there are then going to be lots of additional things that we can think about in terms of how do we get them to start to move again, given that they have this kind of record relief. And one of the things that seems really likely to work against that is when people don't trust that the actual the record relief is actually out there and is going to work, right? Like, if you think, well, it's only 75% likely that I have this expungement, even though somebody told me, I don't really trust them. So you know what? I'm just I'm probably just going to keep doing the same thing that I was doing before. I mean, that's going to be an issue even with the automated expungement. So I think that what we need to do is recognize the huge gain we have in terms of dealing with the uptake gap from automatic expungement and how it opens up all these other great opportunities for experimentation and thinking about how notification and the work that Colleen's doing to magnify a lot of the benefits that we might otherwise expect.
Can I just add an additional point to that as well? And I think just to give an example to that point, even behavior related to how one fills out an application, I think is a good example of kind of that take up challenge that JJ is discussing. Because if you don't have trust in the system, you may continue to check that box in the way that you have previously because you're concerned or you don't know. And so it's simple kind of behavioral nudges like that I think are critical, but that can have huge implications for the benefits of the clean slate if people are unaware of those benefits.
I think that does underscore that this is kind of a pretty high touch product in a way, in the sense of understanding that, first of all, what was on my record in the first place, what has been expunged, but then how do I use that? How can I actually rely upon that in the world? It's not as straightforward answered at all, right? In California, we have certain jobs for which your record will still be available to people who are doing a background check on you, right? So certain licensing jobs, or in education and healthcare, those records will still continue to be available. But for private background checks, in most cases, your record will not be available. Those nuances are very important. There are obviously also certain records that will not be able to be cleared. And so knowing exactly what still remains and what still is there, it's a high touch engagement that needs to answer that question. And so I think as we think about implementation of just mechanical clearance, we want to think about the relationship that then can be built potentially with the expungee to help them go on this journey. A lot of these, as JJ was mentioning before, factors would be potentially considered in the petition process as part of vetting. Am I pursuing those? Do I know that this is the one thing that's blocking me from this next opportunity? Here now we sort of have to, on the back end, now that the expungement has happened, now how do we figure out how do we actually deploy it? There is a back and forth engagement that potentially needs to happen. We've been lucky on our team to have a person who is a social worker who has been working at the public defender for several years now, helping people navigate their reentry and also post expungement provide services to folks as well. And so she has a sort of sensibility of the kind of intenseness of the back and forth that needs to happen, whether it be applying for things or be trying to figure out which resources are available to help carry out a certain process. She has a keen understanding of that and also where people are at. And so we're hopeful to try to scale that capability for some of our expungees and then think about how we can make that available on a broader level. But it is a good, quote unquote, that does require more support, more thoughtfulness. And I think a lot of this, sort of as Dr. Crawford was referring to, kind of understanding the user, understanding what their experience is like, where are there kind of open questions in each person's particular case, and how do we make sure that that information is also available and provided to ensure that that expungement itself can have relevance to them.
Great. Thank you. Thank you, Colleen, and thank you all the panelists. That was great. And it moves me into the next question for Nyron. Your work has emphasized administrative burden and racialized systems, and we know that survey-based research can give us a window into awareness, expectations, and decision-making processes that administrative data can't capture. So thinking about the first survey that CSI commissioned working with you from YouGov and the repeat survey that's now in development, what have we learned about how people with records who are directly impacted by the legal system perceive Clean Slate, and what should we aim to learn about next about automated relief?
Thank you for that question. That's a great question. I want to start with a point of contention. There is some debate about the economic benefits of Clean Slate. There's some work, JJ and others have found that Having a record clear can increase wages and reduce reoffending. Others don't find such effects. But I think that particular finding kind of overlooks the experience of individuals who are going through these processes. And so in the impact and awareness survey that we conducted, we actually are able to understand better how people are perceiving benefits in their own lives outside of the objective economic indicators. And those are also important, right? So it's important to know what Clean Slate does for one's economic opportunities and mobility. It's also important to understand how they're recognizing renewed agency because of this new experience. So out the gate, one of the most important findings that I think come out of the impact and awareness survey is that 70% of the respondents in our survey believe that Clean Slate will improve their lives, right? So out the gate, that's an important finding to highlight, that people believe that they would have renewed opportunities, increased life chances if they did not have a criminal record. We also found that 42% of people reported improvement in work, employment, and personal finances. 35% reported improvement in their personal and family relationships. 34% also reported improvements in their health, particularly mental health and self-esteem. 28% reported improvement in their community and political involvement. About a quarter reported improvement in housing, and 22% reported improvement in education. And so in general, they are perceiving benefits of this particular policy program where they are winners. So I just want to highlight that because I think that's important, in addition to kind of questions of the economic benefit. Folks who are receiving these clearances or this automatic clearance are recognizing that there are potential benefits for them. I think as we move forward, I think the other panelists have noted that notification is an issue, particularly for these automated processes. I think one thing that we have to think a little more about are the different touch points in the process. I think Colleen just alluded to that a moment ago. And the other is, as we think about notification, is the employment of trusted messengers. I think JJ alluded to, or the survey that you all had talk about where people learned about that. We asked the question as well in the impact awareness about where people were learning about Clean Slate. And I think a significant number, more than half, said that they were learning about Clean Slate through the news. About 20% said they were learning about it through legal professionals, like legal aid societies. So there are different touch points, and I think thinking a little more critically about trusted messengers, because it's not always clear whether or not someone receives an official notice from the court or the state saying that this record has been cleared, that they actually believe it or trust it. And so bringing people who also have lived experience in to help spread that message, the effects of that, I think are going to be important to try to unpack as we go forward, thinking about how we can expand notification.
And thank you so much. That's great. I want to move us into thinking about the future of Clean Slate research. So thinking about the next 5 years. This is a 3 or more part question, so bear with me. Thinking about the next 5 years, what methods and data sources are most critical to move the field of research forward? So think about administrative data linkages, longer panels, longitudinal work, qualitative work, randomized notification studies, fidelity, et cetera, based on everything that you've mentioned today. And what is the role of the lived experience of people impacted by the legal system in informing future research?
Can I start?
Yes, please.
So I would say all of the above. I think as researchers, some of us tend to have very siloed views about what methods are important. I think this kind of work lends itself to a multi-method approach. One that we have not seen as much of are experiments or randomized trials. I think that that's going to be the next phase of some of this work, particularly as we think about notification, thinking about what kinds of notifications are most effective in reaching the particular target population. I also think that longer panels are going to be important to think about the long-term impacts, and lived experiences I think are critical. Partly because it's easy to take for granted why people might not engage with these systems. One of the earlier questions that I would get often is, why don't they just do? And I often tell my policy students that we have a Nike approach to public policy, just do it. And that takes for granted that there are reasons, there are rational reasons why people might be avoiding from the state. And the way I always describe it is that very, very few people want to go back to the dog that bit them. And so if you can talk to someone who has a lived experience, it'll help you think more critically about the touch points that might actually create the barriers or the squeeze points that make it more difficult for people to understand why what this process is about, what it's doing, the benefits. Because it's easy to again take for granted that a letter coming from our municipal government or the state government is something that we're actively going to want to engage. And in fact, many people try to avoid those types of communications. And so as we think about how people are going through systems, thinking about design and just the experiences that people are having as they experience the administrative state, right? People have very different experiences with the administrative state, particularly, again, if you've had contact with the criminal legal system, you're going to have a very different experience with the state than someone who has not, right? If you are someone who, and we know that this is also racialized, African American men in particular are less trusting of government. They're especially less trusting of police. And so if you don't have that perspective in view, you can design studies that will ask questions that actually don't account for that.
Yeah, I would echo a lot of what Dr. Crawford just mentioned and say that in our own work, we've definitely found a lot of value in working with impacted students that are on our team. Berkeley and the UC system more generally have something called the Underground Scholars Initiative. And so we're blessed to be able to kind of call upon folks to put together both panels of folks that can do the focus groups. For example, when we were designing our initial outreach, how would you like to be contacted? What would be the right ways to signal sort of in the header of the email or in an outreach that this is information that you actually want to read? It was extremely important. But then actually testing these ideas that we developed through focus group work in survey work and then also in outreach has been really critical to be able to kind of then interpret, sort of take those suggestions, test them, and then interpret them, the results that we get. As we've been thinking about what we might want to test as well, this kind of trusted messenger idea, which has been explored a lot, I think, more so in the voting context and felony reenfranchisement. We've been trying to figure out how to come up with arms of our RCTs that could actually test those hypotheses as well, and potentially, hopefully, come up with findings that would be more generally applicable, not just to Clean Slate, but more generally thinking about notification. I think as we get into an age where more and more of the administrative state is automated, whether it be benefits decisions or it be the use of automation in determining, criminal justice incarceration outcomes in terms of pretrial risk assessments, being able to understand how people perceive these automated decisions and how they want to receive information is a more general question that this research can inform upon. And so I think, again, having people at the table in the research who have those experiences is really critical, and it's definitely helped our research become better.
I agree with all of that, but I want to add a few more things that I think are important to be thinking about. One relates to the kinds of outcomes that I think might move certain kinds of policymakers, in particular, economic outcomes as well as crime-related outcomes. I think better data and better linkages that would allow us to not just look at those in a more systematic, convincing way, but also would allow us to not focus on single jurisdictions. I mean, not surprisingly, you're going to get some variation if you do that. So trying to figure out how to study in broader populations, I think will be really useful. I think that there are people out there whose votes aren't going to be affected by whether or not they think that justice impacted people will be better off. What they want to know is whether or not they and their constituency, some of which includes these people, but probably not the ones they're most worried about, how those people are going to be impacted by this. And so I really think it's important to focus on trying to measure the impact on those outcomes. The other thing I wanted to mention is I think research on design will be really important. So we speak about clean slate as if it's sort of a single thing, but of course there are lots of decisions that need to be made along the way. Eligibility determinations, waiting periods, what sorts of crimes, misdemeanor only, felony and misdemeanor, what kinds of felonies, what kinds of misdemeanors. I would like to think as we acquire a broader range of experiments across the states, as well as better linked and better available data, we're going to be able to study some of those questions. Like my own view is that waiting periods are oftentimes too long. I mean, they have a link in some sense to existing research on desistance, but I think that that we're kind of going with the the lowest common denominator on waiting periods in a lot of states, and I think figuring out how to demonstrate you know in an evidence-based way what are the sort of the best types of waiting periods for which kinds of crimes, and which kinds of crimes are most likely to be appropriate for use of automatic expungement versus petition-based expungement versus none at all, I think is something that I look forward to in the coming years.
Absolutely. And I think each of you touched on this in your introduction, but I would love if you could take just a moment to speak to how you see your current projects on Clean Slate research fitting into this kind of the next 5 years of Clean Slate research. We can start with Myron again.
I'm sorry, Laura, can you repeat the question?
Mhm. How do your upcoming projects and what you're working on now fit into this research agenda for Clean Slate research, thinking about everything that we were just talking about?
Yeah, so I mean, part of just my individual work, and that's the work that I'm doing with you. So not all states have adopted automated systems yet, right? So there are still a number of states and jurisdictions that rely on petition-based systems. And there are a number of burdens that are related to that. And JJ just mentioned one, waiting periods. In some places, you have to have all of your court fines and fees paid in order to be eligible. That can be, and that includes child support, restitution. That can be a huge burden. Recall that most people who have some kind of criminal record are people who are underemployed, maybe experiencing poverty, and so that particular compliance burden can be prohibitive for them. And so it's just thinking again about the ways that we can kind of reduce the burden for people under this idea that there's also a workforce imperative, right? There are economic benefits for both the individual as well as society at large. If you think about poverty as being this spiral to crime, right, which many scholars have argued, one of the worst things that we can do to people who are underemployed or vulnerable is continue to make them vulnerable by reducing their opportunities for employment. And so thinking again, how do we reduce these barriers to get people gainful employment so that they can be productive citizens? And I think that's a win for society. I think that it's an easier sell. I often say that COVID was a blessing and a curse insofar as it gave us a fishbowl perspective. Employers are actually starting to come around to clean slate as well. There are more employers who are coming on board. I moderated a panel for the Congressional Black Caucus on behalf of Clean Slate in September. And we talked a lot about this workforce imperative. And so I think just thinking about how we can actually improve people's economic and social well-being is a net positive for both the individual and for society writ large.
Great, thank you. Colleen or JJ, whoever wants to jump.
I mean,
I
I'll
can
just
jump.
say real quickly, and then I can let Colleen respond. I'm really interested in trying to figure out how, at least in Michigan, how to link different types of state administrative data to individual identifiers to study outcomes, not just using survey evidence or other kinds of evidence, but looking at a much wider range of machine kind of generated data outcomes. I think that is likely to be convincing to a different set of people than the current research is, and so I'm really hoping that my work is able to speak to that.
Yeah, and the work with Paper Prisons Initiative will be focused on the Juneteenth initiative that we talked about earlier, which is focused on two questions. One is about how to notify people effectively, what kind of modalities, texting, calling, email, what kind of messages from what senders are going to be effective, and thinking about what's going to be actually something that can be scaled. One thing that I think we're excited about with respect to our partnership is that there are public defender offices across the country, and they also have similar incentives to try to help their populations get information that's going to benefit them. So, working with public defender has been terrific to just get a sense of how institutionally this type of campaign could actually happen. So we're learning a lot from that. And then once we've actually figured out best ways to notify people, we hope to notify a large number of people and then support them through the public defender services, but then ultimately measure their outcomes along these different dimensions that people have talked about. So hopefully through administrative data as well as survey, and trying to look at a larger range of county level outcomes, given that that's where we're sitting. One area I think that we haven't talked about, but which I think is still also a potential area for Clean Slate to think about, is that, again, as that has been mentioned before, fidelity is really important. And I know you mentioned that, Laura, as one of the priorities of the Clean Slate Initiative. Here at Berkeley, we just have computer scientists who are working on these difficult data problems all the time. And I would imagine that there could be some benefit to looking at it from a research perspective of how to actually implement Clean Slate effectively across these jurisdictions as the movement continues to rack up successes legislatively. Actually getting the work done in the records themselves can be quite daunting. So that was just one idea to throw out there.
That's great. Let's take a moment and move to some questions. And again, anyone who's viewing, you can add a question in the Q&A section or the chat. We had a question from Paul Keefe. This goes to any of the panelists, if you can speak to this. Is there any difference in people's faith that their record was sealed if they are affirmatively informed versus going to a court or government portal to check? I'm not sure that that's something that we have evidence about right now, but
It's a great question. I don't know of any evidence. I mean, I imagine just from research in other fields that having the sort of a person who, especially if they're a trusted messenger, conveying that the problem is solved, that's gonna generate you know better outcomes and more effort and life change and but I don't know that. And you could convince me that there are some negatives to receiving that information from somebody as opposed to thinking of it as private information that you may receive through something that seems somewhat anonymous but is very trustworthy. So there might be positives to both of those approaches, but I'm unaware of any research on it.
we have another question from Anthony Pickens in the chat. As someone with lived experience in the system from age 15 and granted clemency at the age of 39, one of the issues that consistently comes up in the work I have been involved in is about oversight. Who do you think should be responsible for the oversight of the process in the states that adopt automated expungement? Does anybody want to weigh in on that?
That's a great point and a great question. I mean, I think what the research that I did to try to look at the fidelity question, we identified a couple different mechanisms that potentially could be used in this situation. I think there's sort of requirements of audits that could be done on the repositories and the record check systems to try to figure out, that could be built into legislation itself, but there are some, I think, built in like dormant maybe authorities at individual state levels where there should be audits done of what is in the repository. So that's one place. I think academics can obviously do audits as well if they can get access to the data and just trying to do fidelity checks there. But more generally, it seems like it's important to have at least some sort of human contact possibility for people who may think that they should be cleared and aren't, or aren't really sure on what's left in their record, that there be some way to follow up. And so that seems to be a very important component of a notification infrastructure, even if it's just a website. And I believe it's the Michigan portal, which allows for there to be some interaction and follow up. But that seems to be quite critical. And hopefully, as different states are implementing, they're keeping in mind that human in the loop with an even pretty automated system.
I would just add that one of the challenges is that there are multiple state agencies often involved in these processes. So sometimes it can be the state police who are maintaining records. The court administrative system can be a part. Sometimes I think in Pennsylvania, the Board of Pardons plays a role. And so trying to centralize that, I think, to the question is going to be important for oversight. And to JJ's point about design, again, trying to centralize where these records live and who's responsible for oversight, I think is an important question for sure.
I'll pass. I'm happy to move on to another question.
We have another question in the Q&A from Jared Billery. This is to all the panelists. Have there been any thoughts of working with nonprofit legal providers in conducting clean slate research separately from public defenders' offices?
Yes, absolutely. There's ongoing research of that sort where, nonprofit provider here in Detroit, Project Clean Slate. It's not technically a nonprofit; it's a city agency, but it serves that in that role with lawyers that are available to anybody who is a Detroit resident or an employee of the city, and and I think those kinds of collaborations have been super fruitful. And I think that wherever there is such an organization, reaching out to academics to help you think about how to use the data you're collecting and what kinds of data to collect along the way would be wise, because there's maybe some features about how academics conduct research or how people conduct research in general that you can make it a lot stronger if you do certain things and how you collect the data and how you organize things that may not seem obvious to somebody who doesn't do that kind of work all the time. So at the very least, you might want to set yourself up for being able to do that kind of research by talking to a researcher.
And I'll just add that our partnerships with local groups have been really helpful in two ways. One is just to understand the lived experience of what are sort of barriers that people face and how might they want to receive information. We're working with one group in San Jose to put together a video about what are the changes that can happen once you have a record that's been cleared, and sort of provide that testimony and to kind of show that we're sort of working with community. One challenge has been, however, sharing personally identified information about clearances beyond the public defender's office. It's not something that we're able to do. But in one place where that isn't an issue is where we're doing referrals. And this is obviously something we still need to build out, but where people are interested in additional services to nonprofits, whether it be workforce development, nonprofits or others, then we can make those referrals. And so just understanding that there is that expungement is part of a longer journey for people who may then start to seek services and hopefully start to consider their options that are now newly available to them. That's not something that Clean Slate itself or Public Defender can do, but community partners can be a big part of that.
Yeah. Excellent points. Thank you so much. I have one last question. I know we're very short on time, but just want to see if we can talk really quickly. What are some ways that researchers can help policymakers, advocates, and the general public interpret research findings in a way that reflects both the promise and the limitations of early stage research on Clean Slate? So very concise in our last.
Yeah, I mean, I'll just say the devil's in the details. I mean, the evidence is almost always going to be mixed by definition. If you're looking at data, there is variation in things. So, it's almost always going to be able to be able to find some kind of counter study. And so the key thing is recognizing, there's weight with a bunch of evidence, and the details of the experiment in general or the study in general may give us lots of reasons to think, well, this isn't actually even relevant to the kinds of questions I'm talking about. So if you're struggling to really to to understand the exact implications of a study, plenty of us would be happy to help with that. But I would just say be careful and don't draw huge conclusions from like a single study that doesn't seem to support what you're interested in and supporting.
Thank you so much. We are out of time, so let's end on that note. I want to give a huge thank you to our panelists today. This was fantastic. Thank you all so much for lending your time and expertise to this webinar, and thank you all so much for coming again.